Raleigh Tipton with Law Office of Kerry Raleigh Tipton, PA. A lot of my practice is focused on business law, helping businesses identify their legal issues, manage their legal needs. A lot of my experience has been grounded in litigation. And in commercial litigation and contracts, you get a variety of issues that gives you the training for a variety of matters. You'll be dealing with a trade secret one day, maybe an employment law issue, a non-compete, contractual dispute. So the good thing about commercial litigation is every case could be something new. The bad thing about commercial litigation is you're not going to have that rote routine practice where you can just do the cookie cutter answers or thoughts or analysis. But having said that, my very first job out of law school was with the intellectual property firm up in Columbus, Ohio. I maintain the relationship with that firm. I'm still of counsel as an intellectual property associate or of counsel with that firm. And that's Japano Wood out of Columbus. And what I like about intellectual property that started my career and has kind of been involved in my career throughout it, and now that I went on my own, is becoming a more significant part of my practice, is that intellectual property celebrates human intellect and creativity, and so much what you're doing in litigation or helping clients minimize their liability, exposure, which is all important. It's integral to their business, and it's fun in strategizing and helping the clients. But to be a part of something positive with the business, seeing their dream, seeing their idea and making it a reality, and helping them protect their interest as they go through it. So that's one of the things that really draws me to intellectual property. And so today, we'll pause a little second. Hi, Freya. Hi, Mary. How are you? So first, intellectual property. The first slide, this is an example of why I went to law school and I am not a graphic artist or a designer. But I'll point out the different things for you. It's basically the bundle of legal rights that protect the result or the products of your human intellect, your ideas. But the ideas themselves do not have protections. It's what you create through the ideas, through your work or through the expressions, and when they're in some type of tangible medium of expression for copyright, for patent, it's the mechanism, it's the process, it's the actual word or the logo for trademarks. And that's where you have the intellectual property rights to it. And depending on what it is are the different rights that you have. And the key, as I was going through all of this, and I was going through, well, what's the main point? And it's really just like any other property, because I was looking at this from the business owner's perspective, or the entrepreneurs, or the artist, or the photographer. What is it that you need to know? And it's with like any other property, who owns it? And if you own it, how do you protect it? How do you not infringe upon or go trespass on another person's property so that you can advance your interest, your brand, your business, and going forward with that? So who owns it? How do you protect it? And what are some things on the business side that you can do to achieve those goals? And that's what that's the overview of this, and that's what we'll be going through. So just to give you also an example of what I go through when I'm protecting or looking at other people's copyrights or interests. A simple thing like preparing a PowerPoint presentation. It's an example of last night I was finishing up the touches and I thought, wow, it would be really nice to have some images. By the way, this is supposed to be music, a book. This image right here is supposed to be a photograph for you, David. Also maybe an illustration for a card design for you, Mary. Formulas like a scientific efforts or something. My husband's a scientist. So all the things that you can create from human intellect. But at around 9 o'clock last night, I was having trouble finding images. The couple places that I was using, I would find one, but then when I want to find the next one, it wouldn't let me have a grocery cart for it, because you want to make sure that you don't just copy it. You have to look to see whether or not someone owns it, whether or not you can purchase the license to, and in the terms of that licensing. So after about 45 minutes of that, I knew the general image that I want. I said, I'll just design it myself.
Good license size, too.
What was that? Yeah. Anyone, there's a free license to this. If you want to use this, you can. But the listing of things on the side, I know it's kind of hard to see. It's your human intellect, your ideas, your work that comes up with the machines, the processes, the inventions. Those would be things typical of patents. Your photography, your works of expression, your greeting cards, those could be copyrights. Your logos, your slogans, sometimes even the smell and the look of a product could be trade dress and trademarks. So as we go through today, I'm going to sit back down. This just warranted a stand up, I think, because it's, that good. Or not. But as I sit back down, we'll go ahead and talk about the different forms.
What's the second from the last one? I can't.
Right here?
Yeah.
That's smells.
Oh, okay.
Believe it or not, sometimes some perfumes, they can protect their smells. Or I think I was just reading an article a few weeks ago how I think it was a greeting card that associated a smell with it. So whenever you open the greeting card, a certain smell would come with that card. And as people were walking by the store, they could see it. And the issue was that something that could be protected. And the analysis of that case was that it could. Everything is case specific, how they use it and how it distinguishes it from other goods or services.
In that case, is what could be protected is the idea of putting a smell.
Not the idea, but the actual smell that you have with the card.
Linked to
A specific
smell linked
yeah, so you can't prevent someone else from using another smell with another card, but it was that specific smell associated with that specific card.
Okay.
So patents, I'm going to give a very broad overview of patents because here's my disclaimer, I do not do patent work. I know a very good patent attorney, Brittany Maxey. Mike and I both know her. So when I have patent issues, I feel more than comfortable. I will call Brittany and we can work on it together. And Marissa, in a few years, you'll be a patent lawyer as well. She just, for those of you who just joined us, she just passed, or she just graduated from law school. Last May is taking the bar this February, and then we'll go on to take the patent bar, which is a separate bar above and beyond the normal bar.
Awesome.
So patents, there's basically the utility patents, the design patents, and the plant patents, and the definitions are on there. It can't be something that is, it can't just be the idea of the invention, whether or not it's a machine or you have to be able to have it in some type of concrete form, either a prototype or at least the plans for it so that someone could build it from there. You can't just say, oh, I have this idea for a sort of bed that when you lay down on it, it plays your favorite nighttime music and you go to sleep. You might actually create how you would create that to get the patent. The other, I didn't even, this tells you my lack of experience with patents. I wasn't even aware that plant patents until last night, which makes sense, and the different design patents. So when I meet with businesses though, and I'll talk with them because sometimes your processes and the formulas or things that they use, I'll pause and I'll say, wait a second, you might have an intellectual property interest in this. Let's go speak with a patent attorney. So at least you can train to spot the issues and work with them because you don't want them to do something that would harm or jeopardize that patent right.
The bottom one there, design patents, new, original, and ornamental designs of manufactured articles. How is that? Could you say something about that? Because why would that be ornamental, then it would be design, then it would just be, why is that a patent and not just something that you copyright?
Well, I think as the note says, it may be something that could subject you to both. And I think it depends on the specific elements of the designs, how, and Marissa, if you know, you can step in here. I just know basically it is something that is, it could be like a design work or something of a manufacturer thing that gives a decorative or a look or feel to something. And it may also, it's not like you have to choose between patent or copyright. Patent or trademark, you could have both.
May I ask a specific question, or
No.
will it, is that not?
You can ask now, but I'll tell you, for patents, I may not know the answer.
Okay, because I'm having some of my designs
Mhm.
made in different media to take as demonstrations to a trade show of how my designs are applicable to more than just print. So, like, if I make a piece of aluminum wall art that's this big from one of my designs, is that something that could be
I think
done?
that's something that we would speak with Brittany about, because I do know, because your card designs, we definitely know that there's copyright protections there, not just in the wording in your illustrations, but some of your cards actually have different unique shapes to them. And so that could be considered almost like a sculptural type pictorial work in the copyright, but that's something that is a good example of where I'd say, let's pick up the phone and call Brittany and ask her.
Just from a common sense perspective on that, you're taking one of your designs to a place that people are going to be sharing all kinds of ideas. So would you want to risk, taking something like that there and then having somebody copy it?
Well, those are things that we're going to
Yeah.
get to at the end of the do's and don'ts of when you do that, but certainly you should have it protected first. So one, copyright ownership of it creates from the time that it starts from the time that you create it. So if you go there and someone takes it from you, you already have your copyright. Now there's different protections from whether or not you register it, which you should register them before you go, and I'll talk to you about later on why you should do that. And then once you've registered something, it's a part of the public record.
Right.
So it's not like you're showing them any secret information. If you were going to a trade show and you didn't have everything developed yet, and you had an idea or a concept, and you had outlines for it, or basic blueprints of what you wanted to do, I would say you would want to have a non-disclosure agreement first, because that's something that you may not have that final product that could be elevate to the copyright protections that you would need. Okay. So copyright. Copyright is it's when you put the artistic or intellectual work in a tangible medium of expression. The idea of a story for a book. Oh, this novel about a couple who falls in love, but their parents disapprove them. Yes, I just stole from Shakespeare right there. But that's the idea. The idea itself is not subject to copyright, but when you actually write it into the book, the stories, that's what gets you the copyright protection. That's why you'll see movies having the same themes over and over and over again. Photographs subject to copyright protections. Visual arts, sculptures, which when I first you think of the artistic sculptures, right? Sometimes you go into stores and you see those little novelty items that people will sell, little ornamental things, that qualifies as a sculpture. And I've handled clients who've had those copyright infringement claims based on their sculpture, the novelty like gift items being improperly copied by someone else. So there's the whole list of the different examples of copyright protection. Some of the key points with copyrights. It exists upon the creation of the work. The author owns the copyright. But then we look at who's the author in certain situations. And the next point here is the work made for hire. The work made for hire is that the employer generally owns the copyright to the works created by the employee within the scope of the employee's work. Or under statute, there's 9 instances where you can commission someone, and if it's in writing, can also qualify for the work made for hire, but there's only 9 specific scenarios that qualify for that commissioned work for hire status. So the issue comes into being is, well, what if you hire an independent contractor to do work for you? And you don't put it in the contract that what they do is they're doing it as a commission dependent, if it falls under that 9 categories, that you own it, not them. If you don't have it in writing, there's going to be an issue as to who owns it.
Yeah, especially if they're not employed.
Absolutely, absolutely. And I know more and more companies are using independent contractors and consultants, so that's one of the key issues that they really need to be aware of. Once again, who's going to own the resulting product? And how do we make sure that the person who owns it, their rights are protected by it? That needs to be discussed on the front end, needs to be put in writing. And if it doesn't qualify for that work made for hire, those 9 specific instances under the statute, you can also put language in the contract that you hired me to develop X. I agree that you own it either under work made for hire, but should it not qualify under the work made for hire, I agree to assign to you my interest in it. And there are varying ways of how you can do that, or the level of control you can do. The parties can negotiate that. If I'm creating it, do I assign it to you outright so you have all the rights to it? Or am I licensing certain parts of it? Do I reserve some rights for myself? For instance, I know some website developers.
I was just gonna bring that up.
Yeah, I've represented a couple of clients now, working with them to protect their interest as they're having their website company develop their website. Because now when you think of it, the client's going to the website developer saying, I have this idea of what I want my website to look like. The website developer is the one that does all the source code, puts it in a tangible medium of expression. So if you don't talk about it ahead of time, if you don't get it in writing, who owns that website? Who owns that source code? There have been stories where the website developers or the web hosting company will use it as hostage. They'll hijack it away from the company to ensure, if you leave us, we developed it, plus we're hosting it. If you go somewhere else and host it, we're not going to give you the source code for it.
Right.
And now you just wasted thousands and thousands of dollars for something that you can't get to. So that's a key area where it should be discussed on the front end. Yes?
About 17 years ago, when I got my first website, the guy that I was working with registered the website. Little did I know that he registered me, my name, and it became quite an ordeal to get my name back.
It is. And again, it's those are things that if it's discussed on the front, and not just discussed, let me really emphasize this, put it in writing. And if you're not sure of the language to use, not to self-promote attorneys or attorneys like me, it does make a difference to get an attorney to have the right wording and the protections in there. And there's some ways where it could be a discussion too, just like any other property. You can assign it all, you can license all of it, license part of it. I think what I did with what we ended up doing with in the one case with the website developer, we said we own all of it. However, the stuff that is not specific to our business, a grocery cart. A grocery cart, you do source code for the grocery cart and us, you can use that for whoever you want to use for. Anything specific to our business, you can't, it's ours, you don't have any right to use it. If you want to, and it depends on the client, we also gave, in this instance, the website developer the opportunity to at least showcase it for his promotional materials as to examples of what he could do. So that's examples of talking with the other side, the contractor on the front end, making sure everyone is on the same page, it's in writing, who owns what, and how is that person going to protect it. So I'm kind of jumping around here, but what the copyright means is when you're the holder of it, it gives you the exclusive right to reproduce the work, create adaptations to the work, distribute copies, display it, sell it, license it. You get to do that. And again, that right exists from the moment that you create the work. Now, let me talk to you about registration and why it's so significant. When you register with the U.S. Copyright Office, it gives you a couple benefits that you can't have if you just have it on your own. One, it gives you the authority to file an infringement lawsuit in federal court, and it gives you the ability to seek statutory damages, which is the difference between actual damages. And let's put this in perspective. Let me explain actual damages and statutory damages. And I think we're getting, it's the chocolate tea, yeah.
I'm sorry.
Oh no, that's okay. Can you get it?
Yep, it was popular.
And this is the most significant part of these talks is the tea. So
Absolutely.
for anyone out there, and the chocolate truffle tea it's one of my favorites. So actual damages and statutory damages. Actual damages is something you have to prove to show if someone infringed upon your work, they took your work and they used it, how were you damaged by it?
Right.
Can you show that people bought their work instead of buying it from you? That might be hard to show. Can you show that you lost business from it? What if it's something that really is of such an artistic value or artistic nature that there really isn't a monetary value to it? Or it's associated with your brand and now they're using it in a different way. How do you quantitate the value of them changing something that affects your brand? It's very difficult to do. Statutory damages lets you get up, it's anywhere from, I believe, $750,000 to $30,000 per infringement, up to $150,000. And that's part of the law's recognition that it's hard to prove actual damages in artistic expressions of work. If you do not register your work, you can't avail yourself to those statutory damages. Registration costs about $35 to $65, depending. $35 is the norm. There are some other fees depending on how you register it, that could get you to the $65 level. Most works you have to register separately. Sometimes you can register collective works or compilations like photographs. Sometimes you can put a series of photographs together. Newspapers, or if you have like a series of newsletters, you can copyright register them together.
Do they need to be thematically related? Because I found the website very,
The U.S. Copyright Office website?
yeah,
Yeah.
very laborious and unclear and contradicted itself in places.
Oh, how funny. Well, I guess I'm going to not say my next sentence was, go to the U.S. Copyright Office. I find it extremely helpful. I do. You have,
You said
what?
to the office.
Yeah, the U.S. Copyright
She
Office.
said she was to the website.
The website for the U.S. Copyright
Right.
Office? Yeah, I think we're talking about the same
Okay.
thing. It depends on the actual works and the compilation, and I think we'll sit down and look at yours on a one-to-one basis.
Terry, if you don't register, we create copyright material all the time, but we haven't registered anything yet. Is your only remedy then a cease and desist, or do you have no remedy at all?
No, you can still, and so the different types of enforcement is usually the first step is cease and desist, sending a letter to someone. They either follow it or they don't. And that cease and desist can say, stop using my work. And if they don't, then that's continuing on infringement. The cease and desist can also say, stop using my work. Because you already used it, I was damaged by X amount, so please pay me this. But the difference with registering and not registering, if you don't register the work, you can say, if you don't register the work, when you say I've been damaged by X, you have to be able to prove that, and it can't be speculative in nature. It has to be concrete proof supporting your actual damages. If you registered it, you can say, and I'm entitled to damages of up to $150,000 under the statutory damages. Now, when I say of up to, I do want to emphasize it's of up to. Don't think that every time there's infringement, you're going to get $150,000. Like I said, it's $750,000 to $30,000 per infringement, up to $150,000. And so that's the key. And it's a simple thing. Now, you can register after the moment of creation. If you register before someone infringes on your work, you can still avail yourself to the statutory damages. But if they infringe on your work and you find out about it and you think, oh, I'm going to go register it really quick, you can't avail yourself to the statutory damages.
Kerry, if you were a photographer or someone that was in the service industry where you're continuously creating work that would be copyrighted, if you will, so when there's like an event in Tampa Bay and maybe a photographer goes and covers, let's say, Gasparilla and takes all these photos of the event, which ultimately they want to obviously sell those back to the individuals or the companies that they took the photos of, do they have to register that work right after the work has been created, or do they register their entity so all work coming out of that company is...
You don't register an entity, you have to register the works. So you can do, instead of like registering each photograph, but say they have a 100 photographs that day,
Mhm.
they can register all 100 photographs at one time.
Got
But
it.
it's not like you register an entity, then every photograph from that entity is forever covered. It's per work.
Oh, okay.
Yeah.
So it can be rather laborious for someone that's frequently doing work on a daily basis in the public eye that
Yeah.
wants to be protected.
It can be, but if you're like with the photographs, if you do compilations of your work, it's manageable.
Okay.
They can certainly get help from lawyers or others to help it. Actually, I want to point, if you go through your materials,
Mhm.
the first one I want to get caught up. So behind the PowerPoint, here is a chart that provides a summary and overview of the different intellectual property laws. Another example of how you protect other people's works. I saw this chart in one of my intellectual property books last night, and I said, wow, this is wonderful. It basically summarizes everything that I need. It'd be a great handout for the individuals. It's a good summary for me, but it's clearly took a lot of time and effort into this. Maybe arguably I'm using it for education purposes, but it is to you guys could be prospects. Is it purely educational, this seminar? So I contacted the author of it, sent him an email. I said, I have this book in which you did a chapter. You created this awesome table. Is it okay if I use it as part of my presentation? I'm going to copy it as a handout. I'll keep your copyright notice on it, and I'll give you attrition a credit to it during my talk. And he sent me an email back saying yes. So I do want to give him credit right now. And his name is Gordon I. Endow, and he's an intellectual property attorney from California. So
So if you hadn't gone through that process,
I probably would not have used it. Just to be, because I'm conservative in my approach. There's a chance that I could have used it, under, like I said, the fair use doctrine, which we'll come to later on, if this is more of an educational value or if I'm giving commentary on it. But it's such a simple thing. It took me 2 seconds to send the email. I have the reply, of course I'm a lawyer, so I have the email. I printed up the reply, the exchange, written proof. He agreed to it. And again, I think that was extremely, I want to give him credit again. Once again, Gordon Endow. It's a wonderful summary. And why recreate something when it's done so well the first time? So anyways, this table gives you a good overview of the different intellectual property. So when you get a chance, or if you just want to look over from time to time as you're meeting with others, with your own business, with your clients, or whatever, it gives you now something to put on your radar so you can spot issues, so you can help protect your own intellectual property or those of others. Then the next one, and Mike, what made me think of this is there should be a handout from the U.S. Copyright Office that gives you the basics on registration. And I wanted to include that in there because once you get the hang of it, it is something that individuals can do on their own. Sometimes when you're dealing with compilation of works, it can be a little tricky, but it is, between 30.
I found navigating it easy. It's just that that specific question I found
Yeah,
answered in two
okay.
different places, 2 different ways.
Okay.
Yeah.
So, yeah, it is something, and we talked, one of our goals is to get you to the point where you can register them on your own. As part of, especially if it's if you're an artist and you're creating ongoing work, you want to be able to do this on a continual basis. So to answer your question, yes, we'll need to do it on a continual basis. Then the next segments are, we talked a little bit with Jim's question about enforcement and protection of it. So if someone's using your copyright, you can send them the cease and desist, the damages, the statutory damages, you can try to get an injunction, actual damages if you can prove them. And some defenses to copyright infringement include that they created the work independently of your work. So they weren't copying it, they created it by themselves. That there was not a substantial copying, it was just maybe a minuscule little portion of it that did not detract or take from your work. The fair use doctrine, which I'm going to talk about that separately. They did not know that they were infringing on your work. That would be the innocent infringer. That's usually not it's not a get out of jail card for free, but it helps minimize damages. And once you register the work, there's a presumption against that, because registration of it, and if you file your notices of it, you're putting everyone on public notice that it's a registered work, so it takes away from that innocent infringer defense. So the fair use doctrine, that's the doctrine that allows companies to, or not companies, individuals, to use copyrighted works without it constituting infringement of others. It is, you can't do it all the time. The courts look at, oh, I guess I could, there you guys go. In order to determine whether or not a use is fair use, the courts will look at the purpose and character of the use, whether it's for a commercial nature or for educational purpose, the nature of the copyrighted work. Are you copying 100% of it? Are you the amount and the amount and substance of the work that you're copying, the effect of the use upon the potential market for the value of copyrighted work. So, for instance, if you're taking a work from someone else, and now you say it's a photograph, or it's a greeting card, and you take it, and you take their work, but you just change it slightly, but by doing that, you completely diminish the whole brand or style that the artist was trying to work with. That's not going to qualify under the court's going to look at the effect of that use on the copyrighted work, and if it damages the copyrighted work, then it's probably not going to qualify under the fair use doctrine. If you're using something for parody, comedians sometimes can use work as part of a parody for educational purposes, those are more on the side of falling within the fair use doctrine. There's no bright line test that this is always fair use, this is always not fair use. It's fact specific, and that's why in a situation like this, I went ahead and just got permission from the author to use the table. Now the next topic is the copyright notice. And we talked a little bit about this when we were looking at the innocent infringer defense. Copyright notice is putting people on notice, hey, this is a registered work, or this is a copyrighted work. If you registered it, then you can put everyone on notice that it's a registered work. There are 3 essential elements of it: the copyright symbol, the year that it was created, and then the author, the ownership of the work. Then the next handout before I go to the next page is, here's a handout that's copyright table that goes through the duration of a copyright. Because a copyright does not last forever. It's 70 years from the life of the author, or the expiration of 95 years if it's a corporate author, 95 years after publication or registration, or 120 years after the creation of the work for the corporate author. And when you look at things, once something, that copyright expires, then the work becomes part of the public domain, and then people can use it. Public domain does not mean up on a website for public use. That is not putting something in the public domain. Public domain for copyright purposes means the copyright has expired, now people can use it as part of the public domain for use. This chart, I know I just gave the timetables for it, which makes it sound simple, how to determine whether or not a work is in the public domain. This is a nice duration flow chart that goes through of looking at a copyright work. You go through the flow chart to see whether or not and how the copyright expires in the public domain. I won't go through all of it here. I think you can pretty much follow the flow chart yourself. I printed it out once so that you can have it. I know, Mary, you were interested in this in terms of your greeting cards and other work, so I wanted to make sure to include this in part for you. And then for others, just to get an idea of it, 1, the idea of the actual duration of the work, and 2, that sometimes things that appear simple can have complexities to it. So don't guess on these matters. If it's something that you're not sure of, seek advice. Yeah.
On the 70 years, would that be from the time you register it or from the time it was actually created?
The 70 years for the author is from the time of your death. The author's death. I don't want to say your
Okay.
death. Yeah.
But if you're registering something and it's already 30 years old,
It's,
as far as
it's
that
still,
operation.
for an individual, it's measured from the point that the author died. For the corporate work, so say it's a business that registered the work, that's when it's measured from the time of registration or the time of creation. Okay, so moving on,
Is it true for images or for music?
it's
or
for all copyrighted works.
Okay.
Trademarks. I like trademarks. Oh, I went to give this at the beginning of the talk and I forgot. This one product right here exemplifies so many different levels of intellectual property. But Coca-Cola, you see there's the trademark. The shape of the bottle is actually part of their trade dress. And it is, their secret formula is one of the most famous, secretly guarded trade secrets that there is out there. And I know Coca-Cola, it has, there's the power of Coke. When I worked in a larger firm, I'd be in my office. And I wouldn't even be thirsty. I'd be content working. And then all of a sudden, I hear like from outside my office, like that of like a can of pop opening. And next thing you know, I'm still trying to work and I'm just like, get saliva. I'm like, wow, I'm really thirsty. And then I try to work a little bit more, like, I can't concentrate. I need a Coke. So that's branding. It's me falling for commercials. I don't know what it is, but Coke is a classic example of how intellectual property helps a business, its branding, its value. And I went through some examples of trademarks right there, but trademarks can be the logo, the slogan, the design of it, the symbol, the packaging. It is in trademark language. The trademark is what helps identify your good or service from other similar goods or services out in the marketplace. And in fact, one of the standards for trademark infringement is there a likelihood of confusion in the marketplace? Will the consumers likely confuse your product with another product? In looking at whether or not someone is using a trademark that's similar to yours. It is, again, there are different scope of rights for trademarks. There's common law, state law, federal law. I'm going to talk just mainly about federal law because it's nationwide. It gives you the ability to control and to use the mark associated with the goods and services in which you do business or in which you associate the mark with. I want to repeat that. A trademark gives you the right to control or to use the mark associated with the class of goods or services that you use the mark with. So if I have a trademark, say Coca-Cola, right? Trademark. This trademark's probably in a class of services associated with beverages, maybe some formulas, things of that nature. Coca-Cola probably does not have the trademark in, I'm trying to think of something, in, I was going to say medicine, but that's probably, it might even, because at one time it was probably used for medicine. They have apparel, so it would probably be for clothing. Actually, let's look. In your handout is a list of class of service, goods and services. Let's see. Vehicles. There's a trademark class associated with vehicles. I know at some point, I think my dad said they used to use Coke to take rust off of cars up north, so maybe that gets it in there. I don't know, but you get the point. So when you have a trademark, it doesn't mean you have free reign to use that mark in anything and everything that's out there. When you register your trademark, you have to identify the class of goods or services that you use the mark in. And you can choose more than one. You're not limited by just picking one. You look at your business, how you're using it, and then you identify that in your trademark application. I gave you this list of goods or services. This is a summary of the list of classes of goods and services. There's descriptions of how you can figure out what fits into each class, but this gives you an overview of what it is. There are benefits to federal registration of the trademarks, just as there's benefits of copyright registration. One, you can avail yourself to federal court. You use the registered R instead of the TM symbol. You're giving everyone out there on notice that you have the nationwide use to use your mark with those goods or services. It gives you a basis to now maybe apply for registration on foreign registries in other countries.
You said you can use R versus TM.
Yeah. So you actually, it's similar to copyrights, where copyright, you have your rights upon creation of the work. Trademark, you have rights associated with the work from your date of first use of the mark. And that gives you, so when you start using a mark associated with the goods and services that you're using for, you could use the letters TM. But once you register the mark with the U.S. Patent and Trademark Office, then you use the R symbol. And that puts everyone on notice that's a federally registered mark, and with all the benefits that I was just discussing that comes with that mark. So when you're going through it, you need to know the date of first use of commerce. When you first start using the mark, sometimes you have a business idea before you actually start the business. So before you're actually using the mark in commerce, you have an option to file a trademark application for an intent to use the mark, saying, I have this mark design, I haven't used it in commerce yet, but I intend to use it within the next 6 months. Then you could do that. Or you can file an application based on actual use of the mark. In your handouts are flowcharts. I found a whole bunch of flowcharts that I like. So these flowcharts that I got are from the Practical Law Company. It's a legal service that I'm a subscriber of, that as part of that, it gives me the rights to use the works as part of my presentations. And of course, I sent an email clarifying that yesterday. But these are good flowcharts that go through the process of the trademark application process. When you, whether one's the intent to use and one is the actual use. And it goes through some of the issues of what the trademark examiner will look at. So when you register the mark, you register at the U.S. Patent and Trademark Office. One of the first things happen is you have an examining attorney get assigned to the mark. The examining attorney will look at that mark to see if it's similar or confusing, or if it's similarly confusing to any other mark that's being used, or if there's deficiencies on maybe how you identified the mark in the classic goods or something like that. Then the examining attorney will either issue, the mark looks good, let's proceed to registration, or we have some issues with the mark, here's our citations, here our authority, you need to fix it. And you can either go through that process, and if you fix it, it goes on to registration. If you can't fix it, then the mark is abandoned and you lose it. And that's the series of, a little more steps than that, but that's the overview of it. Let's see. Maintenance, enforcement, and remedies. You can also do trademark infringement claims like you would for copyright infringement claims. Do a cease and desist letter as well, the trademark lawsuits. Hopefully it's something that it happens. You see companies will use other people's trademarks quite often. And I want to give some examples of that, but first I want to talk about trade secrets, because I'm going to talk about some intellectual property issues in the news that brings all this together. But first, let's talk about trade secrets. Trade secret is something that has value to your business for the sake of that it's secret. No one else knows it. There's a Uniform Trade Secret Act. Florida has adopted its statute with it that has two components in it. The first component is whatever it is the secret is, your business derives economic value from the fact that it's a secret. And two, it is the subject, you take efforts to protect its secrecy. You can have the greatest, if you have the formula for Coke, but you broadcast it out to the public, it's not going to be a trade secret. If you have the formula for Coke and you just write it down on a piece of paper and have it available on every table or every computer in your business, it's not going to be a trade secret. You have to show efforts of what you do to protect the secrecy of the items that you identify as trade secrets. Now, trade secrets isn't just the formula. It could be your pricing strategy, your profit margin, customer list. It depends. There's case law on where customer lists do not qualify as a trade secret. Customer lists that can just be developed by going through up and down the street and collecting names, most likely not going to be a trade secret. A customer list that you have your list of customers that you use, you note down the preferences, that you know how they like their products or how they like their services based on your years of service for them, that customer list is most likely elevated to a trade secret. One of your formulas, your processes, and when you think of where trade secrets really come in play sometimes is in franchising, right? part of what a franchise does is they license their trade secrets, their know-how to other businesses. They're licensing, sometimes they're licensing, not sometimes, they're usually licensing the trademarks because they want the public to recognize the franchise for whatever it is. But then the specific know-how, the pricing margin, the protocol, they will also license that and guarantee in the franchising agreement, there's a provision in there that the franchisee has to keep the trade secrets secret, and they have to be able to show how they keep them secret. So, now, business decisions. I'm just going to go through. I pulled some articles last night just to see how all this stuff, it affects businesses, large and small. Coca-Cola, right? Back to my favorite Coke recipe. And one of my first talks on trade secrets was in 2006, and I just happened, researching to see what's out there. And in July of 2006, upper-level employees from Coke had access to confidential information of Coke. I don't know if it was the actual formula for Coke, but it was information that Coca-Cola treated as confidential, proprietary, as a trade secret. They contacted Pepsi and said, "Hey, Pepsi, we'd like to sell you this. Will you give us lots of money for Coke's trade secrets?" Pepsi didn't look at it. They contacted Coke, and through that, a federal criminal, investigation was had. Pepsi never looked at the secrets. The wrongdoers, the former employees, were charged with criminal fines, and Coca-Cola got protected as trade secret. Why? Because businesses know the value of trade secrets, plus the damages that someone has for receiving misappropriated trade secrets. Pepsi knew that because of the great efforts that Coca-Cola is known for protecting its trade secrets, Pepsi knew that those individuals that were trying to sell them the trade secrets didn't have the authority to do so. They would be receiving misappropriation of trade secrets, and they could be liable for that as well. So there is value in trade secrets. Another example of the value of trade secrets when it comes to on the employee side, generally Florida and a lot of other states are at will employment situations, right? An employer can fire an employee at any time with or without notice for any lawful reason. Unless you can have a non-compete agreement, which under Florida statute you have to look to make sure if it's reasonable in time, scope of business, line of work, and geography, the Florida courts will enforce it. What if you don't have a non-compete? They have to be in writing. But now a key employee of yours who has access to your trade secrets goes to work for a competitor. You can't prevent them from doing that based on a non-compete, but you may be able to get an injunction from them from working for the competitor if they're a high enough level executive because they had access to your trade secrets that are essential to the business. And if it gets to a situation, there's no way practically that they can pretend that they never saw those trade secrets in their new job, you might be able to get an injunction from that person. It probably won't be as long in duration as a written non-compete, but there are some protections and some teeth in the trade secret laws. Other things in the news, I get an email notice, another thing I've subscribed to that just gives me updates on intellectual property issues, and I think I get one on a daily basis. I just printed this one. I'm not going to go through each one. There's just like 14 key headlines of intellectual property news. You had the Apple versus the Samsung infringement case, where Apple's alleging that Samsung infringed on its patents in using the iPad and iPhone technology in some of the Samsung's phones. Well, in the lawsuit trial yesterday, which has been going on for a long time, in the closing argument, one of the attorneys for Apple made a reference to when he was younger watching TV, and it was an American-made television, and now we don't have those televisions anymore because you know why? Everything's being outsourced overseas. This really now is the integration between trade secret and other areas of law, or not trade secret, intellectual property, other areas of law. The other side, counsel for Samsung, moved for a mistrial, saying that that statement elevated to a racist remark discriminating against Asians for as opposed to non-Americans, and a jury's not supposed to decide a case on the basis of race, American versus or ethnicity or national origin, American versus Asian. I don't think that the court upheld that. I think they let the trial go on, but this is a side point. I have to do my talk with collaborative law, which on these types of cases, when you go to trial, you never know what can happen. I'm sure the attorney for Apple is one of the most seasoned attorneys out there, very skilled, and subjectively looking or objectively looking at it, I don't know if it rises to the ground of mistrial. But one thing that comes out, and now litigation that's gone on for a significant amount of time could be, and mistrial means that everyone goes home and you have to do it all over again. The other side learned your strategy of how you were going to try your case, the time and effort. So if there is an opportunity to resolve disputes outside of the courtroom, see my video on collaborative law practice, then I think businesses should look for it. Sorry, I saw that yesterday. Anyways.
The irony seems awfully rich for Apple to talk about the American product, given that everything's made in China.
I know. It was a gamble that he'd made in the trial. I don't know.
Seems like something that a rookie would make
Yeah.
rather than a seasoned
Yeah.
attorney.
Well, I didn't check on the number of years that he was doing, but I just have to assume that
Obviously didn't think about the
yeah,
repercussions.
the lead trial attorney for Apple, I'm sure, is not just a rookie out of the gate. But and, you know, and sometimes you think things. You think maybe just for maybe the dynamics in that courtroom, there was something in there that we don't know right now that you thought that, oh, this is going to help me connect better with the jury. Then one other thing was Starbucks yesterday lost a 14-year litigation battle. I think it was 14 years. Yeah, a 14-year dispute over a trademark infringement of a small New England coffee house that called itself Charbucks was in the name. It was something Charbucks coffee, and the court denied the infringement aspect of it. So even sophisticated businesses get involved in, 14-year disputes. Starbucks, it's a brand. It's more than, it's a name. It's their product. It's their brand. It's their entity. So you take efforts to protect your business, to protect your brand. So now this is just an overview of how your business and intellectual property comes into play. Everything I'm about to say, please, it's not an exhaustive list of how this can come into play into your business, but I'm just going to start around in the circle and work my way down. First, business name. Unless you're using your surname, your individual name, but if you're using another name, you have to make sure that it's available. And checking to make sure it's available is more than just going on sunbiz.org, which is Florida Secretary of State Department. It's checking the trademark office registrations, maybe there's someone using it on common law use, meaning they didn't register the trademark, but they're using it and they used it before you used it. So you would hate to start your business, devote thousands of dollars in developing your business, only to find out a year later or 6 months later that another business used your name for several years before you, and they actually are right. They have strong trademark claims against you. Now you have to rebrand, rename your business. A lot of stuff that you started you can't undo. You have to start from scratch. So simple step, day one, naming your business, trademark issues. Your brand, we talked about it with Coca-Cola. That could be trademark, trade secrets, patent, everything that affects your brand and your image comes into play. As part of your handouts, I'm not going to go through it here, you do have one other handout that is, think of it just as a briefing point on your branding and essential points for your business. I would encourage you to go through it. It's simple, but it talks about the different elements of what can go into your brand, how you create it, how you protect it, how you use it. One thing about protecting your brand and how you use it, right, is you want to make sure everyone's on the same page, meaning and this is going to tie into employees. If you're making efforts for your trademark or your brand to be used in a certain way, make sure that your marketing materials always reference it consistently. Make sure if you have someone doing your social media and your blogging that they always reference it the same way. Meaning you don't want to add possessives or plurals with it. You don't want to mess around with the trademark itself. If there are copyrighted works, you want to make sure that they're used in the manner in which you want to use it, all in the way that protects your brand. So for a business, you'd want to have policies in place. Whoever's going to be using that work, you want to make sure that they have a clear idea of how they're supposed to use it. Marketing, that goes in with marketing. Investors, say you have this great business idea, but it's not to the point of you don't have the final works of your greeting cards done yet, but you're going to the trade show, right? But you just have the idea, the concept of it. Okay, you try to get people to invest in it. Now that's where you'd want to do a non-disclosure agreement first, because maybe you can't protect the rights on a copyright thing, but you certainly can protect it on a breach of contract type claim. And it gives everyone on notice, again, that you're claiming ownership into this. Everyone's on the same page at the beginning of this is confidential, secret information. Might be able to elevate it as a trade secret, that I'm sharing this with you for investment purposes. Consultants and contractors, we discussed that earlier about who owns what and when. Contractors, most likely, depending on the type of work that they're doing, probably will not fall under the work made for hire. So you have to put in the correct contract provisions in there. Who's going to own the results of their efforts? If you're the business paying them, I'm pretty sure that you, the business, want to own it, not the contractor. So make sure everyone's on the same page with that. Selling and licensing, those are just options. You created the work, now you are the one that can control how others can use it, how you want to sell it, how you can license it. That comes up in franchising is an example of that. The same thing, buying equipment and things like this. I know, look into how you're using equipment. Next time you buy an equipment or a purchase order, you buy a service on a website, or you join even Facebook or Shutterfly, look at their terms of use. You will see there are different licenses that you are giving them when you upload your photographs. So I know sometimes, like if you're going to a printer, right? And you're submitting tons of things to be printed, look at that purchase order. You want to make sure that they just have the right to print it. And it depends on what form that you give it to them, how strong the argument will be, but why take the confusion out? Just make sure everyone's on the same page on the front end. I own this, you're printing it for me, I own it, type thing. Employees, I saved that for last because all of this comes into play here. Your employees, if you have trade secrets, your formulas, your processes, your pricing strategy, if they are true trade secrets, every employee should not have access to it. Only the key employees who need to have access to the trade secrets to do their job should have access to it. You need to make sure that maybe certain files are password protected to show that if someone comes up and says that's not a trade secret, so that you can show and prove that you took efforts as a company to maintain its secrecy. The non-disclosure agreements with your employees. The work, even though employees, their results most likely fall under the work made for hire program. Some issues come up because the work made for hire is works that are a result of the employee that are created within the scope of their employment. What about works that are outside of the scope of their employment? What if they had an idea or some concept, or they're using your product or your equipment, but something that really has nothing to do with their job? Who owns that? So you want to make sure that you have policies, practices, and if the right employees, the contracts in place to protect your intellectual property with that. Who has permission to use your logos, your slogans on, if you're having some people doing your social media pages for you, make sure that they're on the same page, how to use it. So again, this is just a gambit of how intellectual property can affect your business. And I think that is pretty much the overview of what I wanted to talk about. I hope it gives you an idea of what it is and how it comes into play, how it could affect your business. If even maybe not your business, you're an individual and you have some ideas, make sure you have an idea of who owns what. If you created something, and you want to own it, make sure you take all the steps to protect your ownership interest in it. And we had questions during, but if anyone has any other questions, feel free to ask. And if not, I'm going to give you, each of you guys, your suggestions, or, they always say give people a call to action. My call to action is for you to go back and think through your business. Do you have items, creations, works that could rise to the level of intellectual property, whether it's a trademark, a trade secret, copyright, or a patent? And if you do, are you taking the correct measures to protect it? And if you have any questions, feel free to give me a call. All right, thank you. Sorry. All right.